Oh, well, those are news, but I'm watching lots of things.
I did that visit last week.
All rise, circuit court, Judge David Williams preside.
Bow your head for a moment of silence, please. Everybody have a seat.
Control 168.
Commonwealth versus Ronnie Bays.
Oh, more before the promotion.
So.
Did y'all get Mr. Pennington back there?
You need Mr. Pennington.
What do you have, Mr. Stockton?
Well, Your Honor, we thought we'd be farther along in this case than we are, but due to some health issues in our office, we need just a little bit more time in this case. I can approach and go into it if I need to.
It's not
It's
necessary.
not necessary, Judge. I
Yeah.
was conversed.
What kind of, what do you mean more time? You need to set the trial out farther?
Is there is the trial set?
No,
No, we just need another pre-trial.
Okay.
There's some action we need to take prior to set the trial.
that's, and
Okay, let's set it for, next date. Here's July 25th. Is that
That'll be
okay?
fine, Your Honor.
July 25th. You want him for a negotiation day or just,
No, that will be fine.
when is your negotiation day?
It'll
Just
be
for
July the 3rd at 1 o'clock here.
July the 3rd. So much for 4th of July weekend. So, okay, you'll be back here on July the 25th. Okay? Kalen Bolton. Kalen Bolton. It says for review, Mr. Stockton. Is that just,
That's the trial support case, and we set it for review. And I guess, about a year ago, and he's paying all right at this time.
okay. Continue general. Sheila Burchett.
We're working on paperwork next year.
Okay. Joseph Carter. Hello. Commonwealth versus Joseph Carter, 24 CR 0029. Are you Joseph Carter? You're born in 1986. The last four digits, social security number 8914. Somebody's got their microphone on here. Okay. You're here for a pretrial conference in 24 CR 0017. No, excuse me, that was 24 CR 0029.
We would like a date to have a suppression hearing, Judge.
What kind of case is this?
It's a possession case, Your Honor.
Okay, well, you got your calendar with you?
Yes, sir.
Where are the witnesses from?
It's, the state police. We ran, I went to Brandon Fulton's case.
That's correct, Judge.
Okay. How about tomorrow? Can you get him tomorrow?
I can't.
Huh?
Well, I could, I can change my plan.
I'd like to file my motion, Judge.
What'd you say? It's a bad search. All you gotta say is
Well,
a search.
I mean, I could do it tomorrow, and I'll get inside if I.
Yeah, I've got my calendar here. I would like to have it, the negotiation day is July the 3rd.
Do you want to do it that morning? I know we've got Clinton and Cumberland both set July the 3rd here at 1, so I'll be busy from 1 o'clock on. May need a key to close the courthouse.
I got being bone right at 9, but I could
Oh, okay.
be here probably
No,
noon or so.
let's see here. Is the trial still on here for the 9th and 10th?
It is.
How long do you think this suppression hearing would take?
Hour or most, 30, 45 minutes, brother.
We'll just have one witness.
One back on. Body cam, mainly the issue.
Cooking County.
Do they have, I had no state police had that. Check it out.
I got that hanging off. Yeah, so be easy.
Let's see.
We need to get that to you. We need to get that.
Yeah, I've got.
Let's do it on the afternoon of the 10th. Is that okay?
You,
That'd be fine. You want to set it 1 then? Or what time?
Let's set it at 2. We got a trial that might last over into that day.
July the 10th at 2.
Yeah.
That'll work. Try to get you some fire. I bet the one you should go. Might get this motion filed, Judge, and Mr. Stockton disagree to it.
Well, that's the reason I said it so far out. I knew that.
Yeah.
Being a proponent of the Fourth Amendment, you know, constitutional scholar. Okay. Sarah Handy,
Thank you, Judge.
yeah. His next court date will be July 25th, Mr. Bell.
I'm sorry, Judge.
Client, besides being at the suppression hearing, your client's next court date will be July 25th.
Okay,
Okay.
Judge, thank you.
Yes. Sarah Handy. Commonwealth versus Sarah Handy. 23 CR 0044. Are you Sarah Handy?
Yes.
Born in 1995.
Yes, sir.
Last 4 digits, social security number 3672.
Yes.
You have an attorney?
I did. It was Bruce Brown, but since he said that it was dismissed and then reopened, so I would have to say again, and I can't afford to pay him again.
I don't understand. Was this case dismissed?
You know, did you hire him or did you?
Yeah, I hired him.
Okay.
He wasn't a public defender.
It wasn't a conflict case.
How was the case dismissed? I don't know.
He said that it had been dismissed on the 27th of, I think, February maybe.
This is a pretrial diversion revocation. They're trying to revoke it.
He told me that it was dismissed and I would have to pay him again.
Well, you misunderstood what he said, so. You don't have an attorney?
No.
Okay, you need to fill an affidavit out here. What's the revocation?
Your Honor, this is a case where Miss Handy is tested positive for marijuana while she's on probation or supervision. And she has not supplied medical records or anything justifying it. And the cabinet's not even to the position yet that they're approving this use while you're on probation. It's gonna happen, but it's not happened yet. So what we're saying is premature to use marijuana while you're on probation under the act that was enacted, chapter Senate Bill 47. You have to have a bona fide practitioner-patient relationship. And you have to be a registered qualified patient and be approved by the cabinet and have a card in order to use marijuana.
Okay.
And if
come
you've
up
got
here.
that, you need to supply
Come
it
up
to the
here
officer.
and, no, come up here and fill out an affidavit and I'll see if you're eligible. James Jackson. Commonwealth versus James Jackson. 24 CR 0030. Are you James Jackson? You were born in 2001. Last 4 days of Social Security number 4257. You're appearing with Mr. Cross here today for arraignment. You have the right to remain silent, okay? The grand jury of Cumberland County has returned an indictment charging you with trafficking in a controlled substance, possession of drug paraphernalia, operating motor vehicle under the influence, failure to maintain insurance, failure to use an insurance card, speeding, and failure to use a seatbelt. Mr. Cross, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
You have your client here on July the 3rd for negotiations and back here on July the 25th for pretrial to set a date or anything. You can continue in your same bond.
Thank you, Your Honor.
Sign a reciprocal discovery order all this information. You got the information? It's a reciprocal discovery order. They give you anything?
I gave it to him, ready.
I've got the order, but did you there's Siri coming in. Where are you, Siri? Did you give him discovery? Yeah.
We do that through electronic means now.
Now, okay.
Yeah.
Okay. Joseph Massey. What's the James Jackson? Yeah, right.
And that's the one, North Hospital.
Yes.
It was continued by agreement because he's in the hospital. Mr. Stockton, is that the only documentation you have that
I had a document from Norton.
I see it.
That's all I had.
it looks a little weak, you know what I mean? Did y'all follow up on that?
We will.
Okay. Michael Neal. Michael Neal.
The clerk's office downstairs saying he called and said he's running 20 minutes late.
Okay.
Having car trouble. That's the next.
Johnny Riley. Morning, Mr. Riley. Commonwealth versus Johnny Riley, 24 CR 009. Mr. Riley, you born in 1989, last 4 digits, social security number 9320.
Yes, sir.
Says review.
Your Honor, I was intending on dismissing this case because Matthew Riley didn't plea and he's due to be sentenced today. But since he was out of custody before the sentencing, he's got new charges, Mr. Matthew Riley does, and had quite a bit of methamphetamine allegedly on his person. And, but I will go ahead with my deal with Mr. Riley and dismiss this case on the, if it's all right with the court.
Fine.
Because I'm gonna deal with Mr. Riley separate, the other Mr. Riley.
Johnny, you cheated death, man. You're gonna need to be careful. Y'all are hardworking people. Just need to go, work and stay at home and stay out of trouble, okay? See you.
Thank you, Your Honor.
Kelly Scott.
Diversion plea, Your Honor.
Commonwealth versus Kelly Scott, 24 CR 0028. Are you Kelly Scott? Are you Kelly Scott? You have to speak. It's a voice activated microphone.
Yes, Your Honor.
Okay. Were you born in 1966?
Yes, sir.
Last four digits, social security number 4982.
Yes, sir.
I understand that you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Volunteer, yes.
Yeah. Are you the same person just identified in 24 CR 0028?
Yes, sir.
Okay. Is your judgment impaired today in any way?
No, Your Honor.
Have you discussed this charge with your attorney and are you satisfied with his advice?
Yes, Your Honor.
Have you reviewed the evidence which the Commonwealth has against you? Believe you're fully informed about the case?
Yes, Your
You
Honor.
understand you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea guilty, I need to know that you fully understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel at your jury trial, the right to confront, cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to plead beyond a reasonable doubt that you're guilty of charges against you. You understand about entering guilty plea today, you give up all those rights. You understand that? Now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation of the Commonwealth, you have a right to withdraw your plea and proceed to trial. You understand that? Okay, now I'm gonna ask you some qualifying questions here. Have you previously been diverted in the last 5 years?
No, sir.
You have any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion program, the charges will be dismissed.
Yes, sir.
You understand if you don't complete it successfully, you'll be brought back before the court. We'll schedule a sentencing hearing. You'll be a convicted felon.
Yes, Your Honor.
Mr. Stockton, what's the Commonwealth's recommendation?
Your Honor, Mr. Scott will plead guilty to possession of a controlled substance, first degree methamphetamine, receive a sentence of 3 years, pretrial diversion for 5, supervised. He'll be evaluated by the SSC, follow all recommendations. He will obtain gainful employment or do community service and agrees that all evidence in this case will be destroyed.
We didn't mention anything about transfer to Tennessee. It's not in there, but
No.
okay.
Is that your understanding of the offer, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
You're doing so of your own free will because you are guilty and for no other reason. Knowing your constitutional rights, that explains to your desire to proceed with the plea and allow the court to fix your punishment. Is that your signature on the motion? I'll accept the agreement of diversion, or what are the court costs in this case?
$185.
$185. You need some time to pay that? You can pay it downstairs today, okay?
She'll give you a
You're the
receipt.
probation parole officer right back there, okay?
Here for you later.
Sean Wadliff. Sean Wadliff says there's an active warrant, Mr. Stockton. Is that correct?
Yeah, we'll have to put him in, he's the asset.
Okay. Savannah Warner. Morning, Ms. Warner.
Good morning.
24 CR 0024 Commonwealth Kentucky versus Savannah Warner. Miss Warner, were you born in 1997?
Yes, sir.
Last four digits, social security number 9615.
Yes, sir.
Here for the pretrial conference. What has the Commonwealth to say?
We have a diversion plea, Your Honor.
A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Okay, are you the same person that was just identified in 24 CR 0024?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and you feel like you're fully informed about your case?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over them and ask you at the end if you understand, okay? You have a right not to testify against yourself. No one can make the same thing right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to be evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to acquire the Commonwealth plea on a reasonable doubt that you're guilty of charge against you. Understand by entering guilty plea today, you give up all those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided law. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. Do you understand that?
Yes, sir.
Okay, now I'm going to ask a few qualifying questions here. Have you previously been diverted in the last 5 years? Have you had a pretrial diversion in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand if you successfully complete the program, the pretrial diversion program, the charges will be dismissed, pretrial diverted. However, if you do not successfully complete and you're brought back in front of me for a violation and I avoid your pretrial diversion, I'll schedule a sentencing hearing and you'd be a convicted felon. You understand that?
Yes, sir.
And that can be used against you in future felons. You understand that? What is the Commonwealth's recommendation?
Your Honor, Ms. Warner will plead to operate a motor vehicle under impairment, second offense, receive 7 days in jail, pay a $200 fine and costs. She'll plead guilty to wanting the amended charge of wanton endangerment first degree, receive a sentence of 4 years, serve 65 days in jail with the balance pretrial diverted for 4 years, supervised. Those two sentences shall run concurrently for a total of 65 days in jail. She'll receive credit for time served, which is 65 days. She'll enter and complete the Cumberland County Specialty Court and obtain gainful employment, and all evidence in this case will be destroyed.
Is that what you agreed to?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment? Are you pleading guilty because you did these acts?
Yes.
Okay. Are you doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, I've explained, is it still your desire to give up those rights, enter a plea of guilty to the charges and allow the court to fix your punishment?
Yes, sir.
So that's your signature.
Yes, sir.
I'll accept the agreement and sign the diversion order. You'll need to meet with the probation and parole officer.
Then she's got something.
I'll need that as well.
You what?
Then you'll have to go over the DUI guilty plea.
She got a DUI guilty plea.
Yes, Judge.
You realize that's enhanceable also.
Yes,
You
sir.
get another DUI.
Her court was great.
You get another DUI. It could be enhanced even more than this.
Yes, sir.
$850 court costs. You need some time to pay that?
Yeah.
Okay, I'll let you pay it. Can you pay $50 a month?
Yes, sir.
Okay, the first payment's due 30 days from today and 30 days thereafter until you pay the $850, okay? You need to meet with probation and parole officer. Paulette Wilson.
Thank you.
Are you Paulette Wilson?
So,
Is it Pauletta or Paulette?
all right.
Paulette.
This is 24 CR 0019. Were you born in 1974?
Yes,
The last four digits, social security number 5611.
yes.
Yeah, the pretrial. Recent investigation report. Ms. Wilson. Ms. Wilson, I'm looking at the pre-sentence investigation report done by Probation and Parole. If you had time to review that, I can't hear you.
Yes,
Have you had time to review the pre-sentence investigation?
yes,
Is it substantially correct?
yes.
Okay. Counselor, is there any reason this lady should not be sentenced?
No, Your Honor, I would want to note, however, with regards to the pre-sentencing report, in the physical and mental illness portion, I think there are some conditions that are omitted. I think that's something that Ms. Wilson could speak with probation and parole about and get updated, but I think some,
Well, the only thing I know is what's in the report, and I asked you if it was substantially correct.
it's substantially correct, Judge. I think it just omits one medical
Well,
condition.
then it's not substantially correct. Is it? I mean, you want something else in it, we gotta stop it now because it apply, whatever's accepted here is what you go by. Is that correct?
I didn't what you said.
Said there's some mental issues and things that aren't reflected in the pre-sentence investigation report.
There's a paper in that packet that asks you those questions, and if you didn't fill that out and didn't provide that information, it won't be in the PSI.
I think I did. All right.
Okay. Judge, you
Okay,
said
we'll see you next month. Be back here on July the 25th.
Get you much correct.
You're gonna have to contact on this tomorrow, let us know what's going on.
Thank you, Your Honor.
Yeah, that's fine. Tomorrow, we'll go over it here.
Sarah Handy. Ms. Handy, I've looked at your affidavit. I'm going to appoint public advocacy to represent you. One of the reasons I am is you're working full time. You're not making very much money. Most people that come up here aren't making any effort to support themselves at all. So I believe that you deserve the right to have an attorney.
Thank you.
More than people that aren't trying at all. At what you're making, it's very hard to make ends meet, I understand. I don't know whether you were listening a while ago or not, but the Commonwealth says that Miss Handy is on a pretrial diversion, I guess. And there's some reports of her tits dirty on some marijuana, and she claims that she has a prescription from somewhere on it. So you'll need to counsel her on that. Be back here ready. I don't know what to tell you other than you need to get him any kind of prescription or anything you have today and let him get it to the Commonwealth immediately. You agree with that?
Yes, I was thinking that, you don't get your medical
You
records.
can't be self-medicating. I don't want you to say whether you are or whether you aren't. But you can't be doing that. So you need to provide that information to your attorney. Are we ready on,
Ms. McCorkle, Chief Excuse, will be over next month. I don't know if you realize we need this next month, give her attorney time for her.
Ms. McCorkle, were you able to hear that? The previous attorney didn't show up. I appointed her public advocate. And I told her that she needed to immediately provide the Commonwealth with any kind of prescription she says she has for marijuana, and I scheduled it for next month. So you may be excused. The next date is July the 25th, okay?
Yes, sir.
Thank you very much. Thank you very much. Now, you have Sheila Burchett's paperwork ready yet?
Almost, Your Honor, not yet.
Michael Neal, are you here? Okay, let's go to Barron County. Guess it might be a little early. We're a little early for Barron County, I guess. Okay, let's go off the record and recess until these two people catch up, Sheila Burchett and Michael Neal. A motion has been tendered, Ms. Burchett, asking to accept, for me to accept a plea. Are you currently under the influence of drugs or alcohol?
No.
Is the plea freely and voluntarily given? Are you the same person that just identified in 24 CR 0017?
Yeah.
Is your judgment impaired today in any way?
No.
Have you discussed this charge with your attorney and are you satisfied with his advice?
Yeah.
Feel like you're fully informed about all the evidence in the case? Understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
I do.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter higher court if you lose, a right to require the Commonwealth prove beyond reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I do not accept the recommendation, however, you have a right to withdraw your plea and go to trial. Now, have you previously been diverted in the last 5 years? Do you have any felonies in the last 10 years? Are you currently on probation? You understand that if you fully complete the diversion agreement, the charges will be dismissed, pretrial diverted. You understand that? You understand that if you do not successfully complete the diversion program, you will be brought back before the court. Your pretrial diversion will be revoked. The court will schedule a sentencing hearing. You understand that? What is the Commonwealth's recommendation?
Your Honor, Ms. Bursick would plead guilty to DUI first offense, receive 2 days in jail, pay $200 in fines. Also, she would plead guilty to trafficking and controlled substance first degree, first offense, receive a sentence of 5 years, serve 90 days home incarceration with a balance pretrial diverted for 5 years supervised. If she has any jail credit, that would apply to the DUI, but regardless of any jail credit, she would still have the 90 days home incarceration that she has to do.
Okay.
I want to be clear on that.
Now, I realized we need to complete the DUI guilty plea form, tender it this morning too, so.
$435 will be forfeited to the Commonwealth and dispersed according to Kentucky law. And it's, I don't know based on her health if she's able to work or not, but if she is, she'll either work or do community service. And all evidence in this case will be destroyed.
Is that your understanding of the Commonwealth's recommendation? You need to speak up.
Yes.
Okay. Are you pleading guilty because you are guilty of the acts charged in the amended indictment?
Yeah.
Are you doing so of your own free will because you are guilty? Knowing your constitutional rights, as I explained to you, is it still your desire to give up those rights? Enter a plea guilty and allow me to fix the punishment. Okay, you realize that if you are revoked on the pretrial diversion and your sentence, you'll be a convicted felon, and that can be used against you in the future. Okay, and also on the DUI, if you get another DUI, your plea could be used against you in the future. It's enhanceable. You understand that? Is that your signature on the pretrial diversion agreement? And on the DUI? Both of your signature. Yeah, I'll accept the plea. You need some time to, what are the court costs of fines?
$850.
She'll need some time to make payments on fines and such.
Can you pay $50 a month? Okay, you pay your first payment 30 days from today and $50 a month thereafter until it's paid in full. Okay? You need to meet with probation and parole officer right there.
Before we get away to. This fellow right here is gonna-
Michael Neal. Commonwealth of Kentucky versus Michael Neal, 24 CR 0026. Are you Michael Neal?
Yes, ma'am.
Born in 1971.
Yes, sir.
Last 4 digits, social security number 9811. Here for a pretrial conference.
Judge, we have a felony plea.
Motion has been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Is it freely and voluntarily given, your plea?
Yes.
Okay. Are you the Michael Neal that was just identified? Did I just identify you? Did I just identify you as being Marshall Neal? Are you the same person?
Yes, sir.
Okay. Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney?
Yes.
Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you and you believe you're fully informed about your case? Are you fully informed about your case? Have you reviewed
Yes,
the evidence the
yes.
Commonwealth has
I'm
against you?
having a hard time of hearing.
Okay, hand him
this morning.
some earphones.
Just put them in, you put them out.
Under your chin.
Under your chin. Yeah.
Now, can you hear it better now? Okay. Do you believe that you've been fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and United States Constitution. Before I accept the plea of guilty, I need to know that you fully understand those rights. I'm going to go over them and then ask you if you understand them at the end. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called against you, the right to fix evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea that you give up all those rights. You understand that, sir?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Now listen very carefully to what the Commonwealth has to say.
Your Honor, Mr. Neal will plead guilty to wanton endangerment first degree, receive a sentence of 5 years, probated for 5 years, supervised. He was incarcerated at the time we entered this plea, or that we agreed to it, but evidently he's made bond. He'll receive credit for time served. The Commonwealth's dismissing the charge of assault second based on the request of the victim, Brenda Jones. The defendant shall receive credit for time served, obtain gainful employment, and all evidence in this case will be destroyed.
Is that what you agree to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yeah.
Are you doing so of your own free will?
Yes.
Knowing your constitutional rights, as I explained to you, is it still your desire to give up those rights? By hearing a plea of guilty to the charges and allow the court to fix your punishment in the range permitted by law. Is that correct?
Yes.
You understand that after entering a plea of guilty, any future convictions can be enhanced as far as the range of penalty.
Yes. I understand.
Get back over on the defense side.
There's a line I'm not supposed to cross.
There is one, and I just drew it for you. You understand that by entering a guilty plea that any future convictions will be enhanced as for under the persistent felony offender law.
I understand.
Is that your signature there?
Yes, it is.
I'll accept the agreement, order pre-sentence investigation report, set a sentencing date for July the 25th. Now, there is an issue that has come up here. Evidently the surety is requested to be released.
That's an odd situation, Your Honor. The victim actually made Mr. Neal's bond on the assault second charge, and now
It's kind of a New Testament thing.
it is. Now she's here and she's wanting to come off his bond. Brenda Jones, her name.
Okay, well, he's entered a plea. You've agreed to probate.
Yeah.
You want him jailed, or usually when people enter a plea and we probate them, we let them go on. don't we?
Yeah, that's fine with me. I'm not asking to be incarcerated, but I think she should come off the bond.
Okay. That'll be fine. I'll release her from her bond. You need to meet the probation parole officer there. What is this?
That's the release event.
Yeah. Okay, she's releasing the bond. You need to meet with the probation and parole officer there, sir. Now that concludes the live docket, correct?
Yes.
Okay, let's go off the record and we'll go on, with Barron County at 10 o'clock.
Actually, some people, they've already been within.
Okay, wait just a second. Take that back. Let's go back online. Rodney Miller. Mr. Miller is on from the correction. Rodney Miller. Mr. Miller, will you turn on your camera?
Yes, Your Honor, I'm here.
Mr. Pennington, do you represent Mr. Miller?
That is correct, Judge.
Mr. Miller, you born in 1990?
Yes, Your Honor.
Last four digits, social security number?
7516.
Okay, what does the Commonwealth have to say?
Your Honor, Mr. Miller has been in custody, I don't know how many years he could tell us in Indiana. And I don't know, he has some time left on his sentence. I'm moving to dismiss this case without prejudice. But if he ever comes back down here and gets in trouble again, I will re-indict him.
What is the charge?
It's receiving stolen property. I think he's actually serving the sentence in Indiana for the theft. And this is receiving, it's on an RV or a camp.
Mr. Miller, you don't have any objection to this case being dismissed, do you?
No, Your Honor.
That's the correct answer. So it's dismissed
Without prejudice.
without prejudice. So if you ever come down here and get anything, they can bring it back up against you. But as of this, you're released from any charges in this court, okay?
All right, Your Honor, I got one question for you.
Thank you.
Can I, what
Yeah.
about my bond? I paid a full cash bond.
It
Which
was
is
forfeited.
okay.
It was already discharged in 22, it says.
Cause he didn't show up.
It was forfeited because he didn't show up, yeah.
Yeah, I was
thought-
incarcerated.
Wait just a second. Wait just a second.
Okay.
It's already been, serious, or it just tells me discharged.
We'll look and see what happens.
I'm pretty sure.
We forfeited because we didn't check. And it. There's an order to forfeit bond.
Did he fail to appear?
Yes.
He failed to appear and that bond was forfeited. Now, if you think that's
Yes, Your Honor.
incorrect,
I was in custody.
Wait just a second.
Okay.
Wait, just. If you think if you have a good excuse for that, or you want me to reopen that, get a hold of Mr. Pennington and he can file a motion. I can't rule it today because I don't have any facts in front of me, okay?
Okay. All
But
right.
if you were incarcerated and you didn't appear because of that reason, whatever, you need to tell him that, let him file a motion, serve it on the Commonwealth, and I'll hear that, okay?
All righty. All righty.
Okay.
Thank you.
Thank you, yeah.
I just re-indicted.
Recall that, he's finished.
Hey, Dan, if he wants to pursue it, I'll just re-indict him.
You what?
I said if he wants to pursue it, I'll just re-indict.
Well, let's just see why he wasn't here.
Well, I know we never figured it.
Well, I'm, that's what they're gonna have to, you'll have an opportunity to argue the case. I'm not just gonna automatically give it back. We'll take a look at the whole banana, okay?
Okay, kaboom, right? Yes, sir.
Yeah. Okay. Barron County, are you on yet? Barron County, are you on? Hart County, are you on yet?
Say Hart County, sir?
Hart County, yes,
Yes, sir.
Hart County. Commonwealth versus David Hammer in Hart County. Hart County, I only see an empty chair there. Is there an officer or anyone there in the room?
Officer Dyer.
Yeah, we got the witness out.
Well, I've got the witness on, but I got the jail with a empty chair.
Okay, gotcha.
That's what it looks like to me, and he said that the misdemeanor is weak, but the problem is he absconded. I want to make sure. Says he ended up moving in, dating the counselor. That's from the beginning.
Officer Dyer, could you call over there to the Hart County Jail? Do you have their number?
I
Are
can
you-
see if I got it in my cell phone, Judge.
You're good. They got their camera on, but
Yeah, I'll see if I can find a number real quick.
Miss Parker can call, she said.
both of us called their way.
You've got this written around again, it's the time you try to keep her.
Cumberland County Circuit Court, which is for they were showing on Plea, they were showing an English there. So we were just waiting for you to be a sentence to go to the room. All right, they can watching out on him. They'll try to reach a decision. And I do know, I've sent them a message and asked them to remove themselves. One of them is, the ones where I can't tell which one it is, and I don't want to kick the wrong person out. But if they just make it, I'm gonna put participants in. Watch on YouTube. That's what I said last.
If you, I don't know how some of the people on here got this link, but if you are not a court participant, if you're not in front of the court yourself or a lawyer or a jail, you can get on YouTube. But you cannot be on this link here. Get off this link now. And I don't know who gave the link out, but it's not appropriate. So if you don't get off, we're going to take everybody off and start all over again.
A lot of people watch court. They really don't.
Okay, we're back online now. Commonwealth versus David Hammer. 23 CR 0027. Are you David Hammer?
Yes, sir.
Born in 1987.
Yes, sir.
Last four digits of social security number 2512.
Yes, sir.
You're on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Hammer has a 12-year, 6-month sentence. And I got a report from Mr. Dyer that he was told to report in February and never reported back. And then he has 2 misdemeanor arrests since then. So.
Okay, you want to stipulate?
Well, Judge, I actually just found out where Mr. Hammer was yesterday, so I've not had a chance to speak to him, so I can't advise him to stipulate or not.
What's he being held on now?
I think it's this probation violation. Is that correct, Mr. Dyer? Have you got a warrant on this? Or has he been held on
Yes,
other
sir. I believe
charges?
it's correct.
He has that, and then he also has a Hart County folder, a 500 cash over sale of stolen property.
Okay, we'll put a holder, we'll keep our holder in place. He'll next appear here on July the 25th. Mr. Mr. Dyer, if you could make yourself available on that date, okay? Officer
Yes, sir.
Dyer, I mean. Okay,
I'll be able to see you, Mr. Hammer,
okay.
or get with you.
Hart County, you may be excused. Thank you very much.
Thank you, Judge.
Yeah. Barron County.
Yes, Your Honor.
Have Richard Armstrong for sentencing. Give him a sentencing.
Oh, yeah.
Are you Richard Armstrong?
Yes, Your Honor.
You born in 2000?
Yes, sir.
Last four digits of social security number 719.
Yes.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by Probation and Parole?
I'm sorry, Your Honor, I didn't catch that.
Have you had an opportunity to go over this multi-page document, the pre-sentence investigation report? Have you seen it?
Okay, a different report that my lawyer gave me. I've had another incident.
I
I was,
can't understand what you're saying. Hold your head up there and say, well, have you reviewed this document?
Your Honor, I've reviewed any document of what my lawyer had for me, and I guess I violated it.
Judge, if I may, and hold on for a second, Mr. Armstrong, don't say anything else. Judge, the basis for this revocation was a case out of Barron County. It's my understanding that Mr. Armstrong may be having an evaluation in that case. I don't know that he understands or
Did you go over
understood.
there and meet with him with this and go through it?
I did, Judge, but I don't know that he comprehended.
I'm asking you, were you present in person and go over this with him?
Yes.
Your Honor, he did appear in front of Judge Alexander in Mediated on Tuesday, and he goes back in front of him July the 23rd, and he has started. Understanding charges.
Your Honor, is there any way I can get house arrest?
Well, I've got to sentence you first. I asked you the question. Did your attorney go over to jail there and go over this pre-sentence investigation report with you?
Yes, Your Honor.
Were the things contained in it correct?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced?
Judge, just what I stated on the record with regards to what I believe
Okay,
is.
then we won't sentence him then. We'll schedule him on July the 25th. Your lawyer will be back over and talk to you again, sir, and you'll be scheduled for July the 25th.
Thank you, Your Honor.
Now, he's on hold here too, okay?
Yes, Your Honor.
Okay. Okay. Thank you. Barron County can be released.
Thank you, Your Honor.
You. Adair County, are you on the line? We're still a little early.
We're here.
You want to start now? You want to start now, or you want to wait till 10:30?
We can go ahead and start now if you want to. I've got them all ready.
That'll be fine. You got all of them lined up.
I sure do.
Commonwealth versus Gerald Beckman. Good morning, Mr. Beckner. You're here on 22 CR 00106. Are you Gerald Beckner?
Yes, sir.
You were born in 1977. Were the last four digits of your social security number 4499?
Yes, Your Honor.
Okay, we're here on a probation application. What does the Commonwealth have to say?
Did he get arrested? He was 17, right? He's out driving with the hardship license. Son of a bitch.
What do you have to say?
Your Honor, this is a 3-year sentence on possession of controlled substance. I'll let Mr. Garner testify in this case. That's all right.
Well, just tell us what it is.
Well, Mr. Beckner was on probation here. He had a DUI, so he had a hardship license. He was driving on the days that he wasn't permitted to drive on the hardship license. He left the state of Kentucky without permission, went to Tennessee, and was arrested down there for open alcohol container. So that's.
Does your client want to stipulate to this?
Judge, actually what we were asking for is for the
Does he
court.
want to stipulate to the actions? Then you can ask.
Stipulate, yes, we would stipulate to the
Okay, now,
actions.
you want to say something?
Yes, Your Honor. What we would ask for is that the court, I think Mr. Beckner's been in since June 5th or 6th, approaching 30 days. Judge, what we would ask is for the imposition of a 30-day sanction. Mr. Beckner, and we need to put him under oath, we can. He was part of the being in Tennessee, and I understand the facts was he was looking for employment. He had a significant time that he was on home
Does he live in
incarceration.
Tennessee? Lives in Kentucky? What does the Commonwealth have to say?
Well, it's a possession.
Speak up just a
It's a
little bit.
possession case. What concerns me was he had a hardship license. He was using it inappropriately. He was initially charged with driving under the influence, but the state police down there said he wasn't under the influence. But he had an open bottle of Bud Light beer in a cab with a half of a 6-pack. 2 beers were already missing. So I don't know what you do to protect the public. He's got a DUI already. He doesn't have a license. He's on probation and he's out driving around Tennessee drinking. So I don't know. What do you do?
Again, Judge, I think if we're getting into what Tennessee was doing,
Now, I'm getting
They
into
did
what
what-
Mr. Beckner was doing.
I
Mr. Beckner left the Commonwealth of Kentucky without permission. He was drinking alcoholic beverages and illegally driving after he'd been given the privilege on a hardship license. So I have no sympathy for Mr. Beckner on this thing. And one of the 2 or 3 things that bother me the most is when people get out and drive in violation of orders or have a weapon. Those are the 2 things that bother me. Because as sure as say he runs over a school bus or something down there or anywhere. So I'm going to revoke Mr. Beckner. Okay, next is Mark Cruz. Mark Cruz. Mark Cruz. Are you Mark Cruz?
Yes,
This is 24 CR 0014. Were you born in 1960, Mr. Cruz?
yes,
Last 4 digits, social security number 3369.
yes,
You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by Probation and Parole?
yes,
Is it substantially correct?
yes.
Is there any reason this gentleman should not be sentenced today?
no, Your Honor.
Upon a plea of guilty, possession of controlled substance, first degree meth, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised on a plea of guilty to possession of controlled substance, second degree, sentence of 12 months. Now, is that sentence also probated, Mr. Stockton?
Yes, Your Honor.
Now, I know they run together, but both of them are probated, correct?
Yes, Judge.
Okay. The 2 sentences shall be probated and run concurrently. He shall receive credit for time served. What are the court costs in this case?
$225.
$225. I'm gonna give you some time to pay that. You paid it $50 a month. The first payment's made 30 days from today when you get released. When can you meet with probation and parole?
Tomorrow's fine. Tomorrow morning.
What time?
Tomorrow morning, 9 a.m. is fine, Your Honor.
Okay, I'm gonna release you in the morning at 8:30, go over to probation and parole, meet with them and be on your way rejoicing, okay?
Okay.
Well,
He does have a Grayson County holder.
yeah.
Okay, well, then the probation and parole will be over there to see you tomorrow. But as far as this court is concerned, we're finished and he'll go over an interview and you can do what you need to do in Grayson County, okay? Thank you. Charles Dyer. Charles Dyer. Good morning, Mr. Dyer.
Your Honor.
This is 24 CR 0018 Commonwealth versus Charles Dyer. Mr. Dyer, were you born in 1973?
Yes, sir.
It's 4 digits, social security number 5164.
Sure.
We're here on a pretrial conference. Your attorney is Mr. Cross is present. What does the Commonwealth have to say?
Your Honor, Mr. Cross is one more pretrial conference.
You want a negotiation on July 3rd?
Yes, Your Honor.
Okay, you'd be ordered to attend negotiation on July 3rd. You're in Cumberland County. The next court date is July the 25th. You want him transported, Mr.
I'll submit a transport order to have him here on both dates.
Okay. Your attorney will be up to see you.
All right, thank you, sir.
Oscar Fairley. Commonwealth Kentucky versus Oscar Fairley, 19 CR 0089. Are you Oscar Fairley?
Yes, sir.
Born in 1992.
Yes, sir.
Last 4 digits, social security number 5643.
Yes, sir.
We're on a shock probation revocation. What does the Commonwealth have to say?
Your Honor, he has a 5-year sentence on receiving stolen property. Since February the 8th, he's had 3 positive meth charge positives. He's referred to the SSC. He was supposed to go to treatment, then he absconded April 3rd.
You stipulate?
Yes, Judge, I've discussed this with Mr. Fairley and we're willing to stipulate.
Okay, we will go ahead and revoke him and then make sure he gets the credit for time served. Okay. Okay, thank you, Mr. Farley. Commonwealth versus Chad Faulkner. Good morning, Mr. Faulkner. This is 24 CR 0022 Commonwealth Kentucky versus Chad Faulkner. Are you Chad Faulkner?
Yes, sir.
Born in 1983.
Yes, sir.
Last 4 digits of your social security number is 7024. You're here today for the purpose of sentencing. Mr. Faulkner, have you reviewed the pre-sentence investigation report on the probation parole?
Yes, sir.
Is it substantially correct? Is there any reason Mr. Faulkner should not be sentenced today?
No, Your Honor, but just as a point of order, there is a second case. I think the case number is 24 CR 11. Is that correct, Ms. Smith?
Yes, it is.
Yeah, 24 CR 11, 24 CR 0022.
Aside from that, Judge, I just wanted to make sure.
You're both on here.
So, yes, Judge, he's ready to be sentenced.
On a plea of guilty, possession of controlled substance, first degree, and 24 CR 0011, the defendant shall receive a sentence of 3 years. On a plea of guilty, possession of controlled substance, first degree, and 24 CR 0022, the defendant shall receive a sentence of 3 years. The 2 sentences, however, shall run consecutively for 6 years. Each shall serve 100 days and be probated for 5 years. Probation to be supervised. Upon a plea of guilty to operate your motor vehicle with alcohol concentration or under the influence, he shall receive 7 days in jail and receive a fine of $350. They shall run concurrently with the 100 days previously sentenced. Defendant agrees to enroll and complete a long-term treatment for a minimum of 6 months in Spark in Russell County. He shall not be released, and he shall not be released prior to final sentencing. What are the total fine and court costs on this?
The 24 CR 22 is 185, and then the 24 CR 11 is 1,000.
$1,185?
Correct.
$1,185, and when you get out of treatment, you can start paying on that at $75 a month. That'll let you get back on your feet, okay? When you get out of treatment. Now, when you entered these pleas, you knew that these were enhanceable. If you got another felony, that they could be used again. And you know the DUI is enhanceable. You knew that also, correct? Is that correct?
Yes, sir.
Okay. Okay, well, how many of his 100 days does he have in on this report?
All of them, Judge. Is at 117 days. Spark,
Okay, so we get him a Spark, who's gonna transport him to Spark?
Spark will be transporting him in the morning.
Okay, well, I'll sign your release, and I guess Mr. Pennington says that Spark will be up to get you in the morning, okay?
Thank you, sir.
Yes. What'd you say?
I do, I complete forms on for it.
Okay, we'll need a DUI guilty plea form signed for you. So
Okay.
Mr. Pennington will get that up there to you.
Yeah, and I'll stop on my way through.
Thank you, sir.
Okay. Well, thank you. Aiden Fields. Aiden Fields.
Does he live here?
Commonwealth versus Aiden Fields, 23 CR 0051. Are you Aiden Fields?
Yes.
You were born in 1977.
Yes, sir.
Last four digits of your social security number 0320. Is that correct? 0320? Okay. You're here on a pretrial diversion revocation. What is the Commonwealth have to say?
Your Honor, he has a possession of controlled substance, 3-year sentence. And in May, he tested positive for methamphetamines. He also, didn't report to his probation officer after May the 24th. Mr. Pennington's advised that he's interested in going into drug court. If he lives in Clinton County and wants to go and will stay in custody until he's oriented, I will agree to that if the court will.
You live in Clinton County, Mr. Fields?
Yes, I do.
Okay, well, what they're saying is that they're willing to give you a chance not to revoke your pretrial diversion if you will participate in the Clinton County Drug Court. Are you willing to do that?
Yes, sir, I am.
Okay, well, you're gonna have to stay incarcerated until they do the evaluation and the vote on you. So it'll be a few days, but this way you won't become a felon on this thing, okay? So I hope you work hard with them on the drug court, and they'll be up to see you soon on that, okay?
Thank you.
Thank you. Jeremy Jones.
Judge, may I be excused? That's all I had, sir.
Absolutely. You're gonna miss you.
Thank you. Have a great day.
Commonwealth versus Jeremy Jones. Are you Jeremy Jones?
Yes, sir.
You were born in 1986.
Yes, sir.
Last four digits of your social security number 8459. Is that correct?
Yes, sir.
Okay, you're on probation revocation in 18 CR 0077 and 19 CR 004, and a pretrial conference on your newest charge in 21 CR 0087. What does the Commonwealth have to say?
Your Honor, part of the basis for the revocation is that he never appeared for the pretrial conference several years ago. It's still pending in this court. I don't know if you want to set that for negotiation day and let's try to wrap all this up or have the hearing.
That'd be the smart thing to do to wrap all your stuff up. We'll schedule for negotiation day on July 3rd. And the next court appearance is on July the 25th. Your attorney will be to talk to, but what they're gonna try to do, Mr. Jones, is wrap all your things up and get you finished with this, okay? So your attorney will be up, you said, okay, thank you very much.
Thank you.
Joanna Kittrell. Joanna Kittrell. Joanna Kittrell, 24 CI 0027. Are you Joanna Kittrell?
Yes, sir. How are you?
I'm blessed, thank you. Were you born in 1997?
Yes, sir.
You last four digits of your social security number 0105.
Yes, sir.
Hey, it says here a competency hearing. What does the Commonwealth have to say?
That's correct, Your Honor. She was evaluated by Dr. Anderson. And I think I've had so much of my staff out here lately, we didn't get in touch with Dr. Anderson. So if she won't stipulate, we'll need to schedule this for a hearing.
And yeah, Judge, we're not willing to stipulate. I think I have several misgivings with doctor's reports.
Okay, you want to schedule a hearing?
Yes, Your Honor.
Okay, well, you want to wait till the next, what's she charged with?
Fleeing and evading. I'll have to look at all the charges.
for several traffic events as judge. You
Yeah, speed,
Ended up in-
no insurance, wanting endangerment, fleeing and evading motor vehicle.
Scheduled for July 25th
That's fine, Judge.
for a competency hearing. Thank you very much.
I'll be able to speak to you, Josie.
Thank you so much.
Larry Minge. Larry Minge, is that how you say the last name?
Mingy.
Mingy, I'm sorry, Mr. Mingy. Good morning. This is Commonwealth Attorney, Commonwealth Kentucky versus Larry Mingy, 24 CR 0034. You're here for the purpose of arraignment. You have a right to remain silent. Your attorney is present here. The grand jury of Cumberland County has returned an indictment charging you with trafficking controlled substance first degree, possession of controlled substance in the first degree, possession of controlled substance in the first degree, possession of drug paraphernalia, possession of marijuana, operating motor vehicle under the influence, careless driving, and failure to signal. Do you understand those charges?
Yes.
Counselor, do you acknowledge Mr. Mingy's identity, receipt, indictment, await formal arraignment, and arraignment, interplea of not guilty, reserving all pleas?
Yes, Your Honor.
Sign a reciprocal discovery order, Mr. Mingy, and the Commonwealth will be providing your attorney electronically the information necessary to prepare your defense. Order you to be present on July 3rd for a negotiation date and July the 25th for the next court date. Okay,
And Judge, if I
Okay.
could inquire, need his bond.
what is Mr. Mingy?
Yes, Your Honor, it is, 25,000 in cash or twice the property.
Mr. Mingy, have you got anybody that can put up any property to get you out?
No.
You can discuss the situation.
Yes, Your Honor.
Mr. Mingy, your attorney will discuss your bond situation with the Commonwealth, okay? He'll be back in contact with you. Thank you
Okay.
very much. Commonwealth versus Austin New.
Good morning, Your Honor. This is Travis Locke. I represent Mr. New. I'm on Zoom, but it won't let me start my video.
Okay, that's fine. Commonwealth versus Austin New, 24 CR 0032. Are you Austin New,
Yes, sir.
born in 1986?
Yes, sir.
It's 4 digits of your social security number, 8510. You're there, Mr. Locke, we can see you now. You're here for the purpose of arraignment, Mr. New. You have a right to remain silent. At any time you don't understand the proceeding, we can get your attorney on the phone. You can ask me questions. The grand jury of Cumberland County has indicted you with the charge of incest, 20 counts. Also with promoting a sexual performance by a minor, and rape in the 3rd degree, 20 counts. In possession or viewing of a matter portraying a sexual performance by a minor, 2 counts. You understand what those charges are? You understand what those charges are, Mr. Nick?
Yes,
I'm not
sir.
asking if you understand what they are. Okay, Counselor, have you received copies of the indictment yet?
Yes, Your Honor.
You acknowledge the identity of Mr. New?
Yes.
Receive the indictment, waive formal reading and arraignment, interplea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Then you have a motion for a bill of particulars, but it also has 24 CI 0033. Is there another indictment?
Yes.
You have it?
It's from the.
Okay.
Yeah.
I didn't see it. Okay, there's a subsequent indictment, 24 CR 0033, possession of controlled substance in the 1st degree, and possession of controlled substance in the 3rd degree. You also enter pleas of not guilty on those charges for Mr. New, and you acknowledge receipt of the indictments, correct?
Yes, Your Honor.
Now, what about the motion for bill of particulars? We have I'm signing a reciprocal discovery order on both cases. And the Commonwealth will provide electronically to you information.
I think we've already provided everything, Mr.
Commonwealth says they've already provided. Now, some of the things you provided are of a sensitive nature. Is that correct?
That's correct.
Okay.
And there is, I would say there's an advocacy center interview that was done in Illinois that we do not have possession of yet, that we can make arrangements for Mr. Locke to view that when we receive it. And also, if he's wanting
Well,
particular,
let's,
go ahead.
did you hear about the advocacy center interview, Mr. Locke?
Yes, I did, Your Honor.
They say they do not have that in their possession yet, and they'll provide you that as soon as they get it. Now, what else do you have, Mr. Stockton?
The other thing is that in his bill of particulars, he's requesting specific incidents as far as the facts of each incident. The minor child's now in Illinois too, and before I can answer that, I'd probably have to meet with her. That's the only issue there.
Commonwealth needs to make sure they give you a full and complete answer to your bill of particulars. They say that they're gonna have to interview the alleged victim. And they'll get, when do you,
We've not set that up because she's currently living with her mother in
Well,
Illinois.
so you maybe before the next rule day?
Awesome. I didn't want to do it this summer before she goes back to school. That's definitely. And it'd have to be in July. So.
Well, I
We'll
would
try to make
request
arrangements.
that you do the interview before, let's say before July 20th maybe, and that way you can provide it to him 5 days before the next rule day, in case you have any motions to supplement that, okay?
Yes, Your Honor. So we'll be there for a pretrial on July 25th. Is that correct?
There's no reason to have a negotiation day on this yet. So I would think that if he provides you this information, if he does the interview with the alleged victim and provides it to you by the 20th, you can determine whether you need any additional time or have any additional motions and can file them on the 25th. If not, we'll come back on the 25th to schedule a trial. Okay?
Yes, Your Honor.
Okay, is there anything else, Mr. Stockton?
No.
Okay, that concludes our business with Mr. New. Matthew Riley. Matthew Riley.
Your Honor, I'm here.
Commonwealth versus Matthew Riley. 24 CR 008. Are you Matthew Riley?
Yes, sir, I am.
Born in 1968.
Yes, sir.
Last four digits, social security number 8553. We're
Sir,
on
it
24 CR 08 for sentencing. Have you had an opportunity? What is this? Okay. Now, you're here today for sentencing. Have you looked at the pre-sentence investigation report about probation and parole?
Yes, I have. There are some,
Substantial-
there are some errors in there, Your Honor.
Okay, tell me what they are.
The death dates of my mother and my father, the addresses of my siblings, several things.
Well, you have to tell
Says
me
my
what
mother,
they are.
it says my
Let's
mother
go-
was deceased. Okay.
Wait, let's one by one. Tell me the first mistake.
Says my mother was deceased, in May 30th of 2024. My mother died, August the 7th of 2020.
Okay, we'll make that note. Now, what's the next mistake?
My father said he was deceased, September 4th, 2014. He died August the 27th of 2014.
Okay, we'll make that change. What else do you have?
Okay, it says, Kathy Wade, my sister, lives on Garmin Ferry Road. She lives in Albany, Kentucky. I don't know the exact address, but I know she lives in Clinton County.
What's her name? What's your new last name?
Her new last name is Stearns.
Okay, so that needs to be changed also. Okay, what else?
Okay, it says, my brother Robert Riley address is 192 Riordan Road, Horse Cave, Kentucky. He lives directly behind Cash Express in Burkesville, Kentucky.
Okay, You make that note. That's on Church Street.
Church Street.
Now go ahead.
Okay, that was right, and that was, okay, that's it on that.
Okay. Now, is there any reason why this gentleman should not be sentenced today?
Yes, Your Honor.
Okay, Commonwealth says yes. What do you have to say?
Well, I don't know that he's eligible, he will be eligible for probation. My understanding is he's got new charges. And it's alleged he may have
You
been
need
in,
to speak up, son.
it's alleged that he may have been in possession of a half a pound of methamphetamine. And if that's the case, I think the probation may be moot in this case. So if the court wants to go ahead and grant probation, they can, but I don't know that he'll ever get out for a while.
And Mr. Riley, don't say anything.
There's a possibility. I ain't saying
Yeah.
for sure, I'm just saying.
Your Honor, I was informed about that case today. Mr. Pennington did the preliminary hearing in it. My understanding is there are some co-defendants in that case. It does sound like a rather complicated case and of who may have done what, and I don't even know the co-defendants' names, Your Honor, at this point. I didn't know if the court may consider just putting off sentencing for 1 month so I could look at it a little bit more to see if this would still be a possibility. Or if,
What they're saying, Mr. Riley, and you don't need to say anything, your attorney, Mr. Pennington, that's representing you in the other cases present, can hear what's going on also. It's their advice that I take this sentencing under advisement so they can look in to the other charges against you. That way I do not just summarily deny your motion for probation here, or the probation order rather. So I will put off I'll put off sentencing to July the 25th, and maybe your attorneys can present evidence to the Commonwealth that would allow me to proceed with the probation, okay?
Yes,
Thank
sir.
you very much.
Thank you.
thank you.
John Scott. Commonwealth versus John Scott. Are you John Scott?
Yes, sir.
You were born in 1962?
Yes, sir.
Last 4 digits of social security number 9063.
Yes, sir.
You're on 23 CR 0045, a motion for shock probation. Mr. Pennington, what do you have to say?
Judge, it's my understanding that Mr. Scott is going to be making parole, that his parole plan was approved, so it would negate this motion for shock probation. Mr. Scott, is that correct?
Yes, sir.
And when's he gonna make parole? Has he already made it?
He was recommended June 6th, Your Honor, so we're just waiting on the procedure to get him out.
Okay, well, your attorney will keep this on the radar screen, and for some reason you don't make the parole, I'll hold this in abeyance so we consider your shock probation if something happens and you don't make. They say you've been recommended for parole, but if something happens between now and then, we'll keep this on the radar, okay?
Okay.
Okay, thank you. Robert
Thank you.
Young. Good morning, Mr. Young.
Morning.
Commonwealth of Kentucky versus Robert Young, 24 CR 0020. Mr. Young, were you born in 1978?
Yes,
Last 4 digits, social security number 3613.
yes.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct.
Yes, sir.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
If on a plea of guilty, possession of controlled substance, first degree, the defendant shall receive a sentence of 2 years, probate for 5 years to be supervised. It shall run consecutively to 22 CR 0025. He agrees to enroll in the Cumberland County Special Court, and he shall be released to orientation, but not prior to file. Has he been oriented yet, Mr. Stockton?
I think he was voted on this morning.
He was voted, you were voted on and approved today, so they'll get in contact for your orientation, and when your orientation comes, I'll let you out on that day, okay? Now, what were the court costs in this case? Is that all you paid? How much?
$185.
$185, and I'll allow you to pay that at $30 a month, Mr. Young, because you're probably not on your feet yet, Okay, so you pay the first $30, 30 days, you pay $30 every 30 days until you get the amount paid, okay? So they'll be up to schedule orientation. Is there anybody else there that Adair County has for us? Is that it?
Do you have Janessa Smith on today? I thought I seen her on the docket, but
What is Janessa Smith's case?
Oh, I think it may end up being a revocation, but I don't think it's been, there's nothing been filed yet.
A motion has not been filed in her case yet for any revocation, okay? So
Okay.
probably next month. Okay, thank you very much. Thank you all for
Thank you.
cooperation. Okay, is there anything else to come on the criminal docket? What docket?
The burden dismissal.
Yeah, I don't mind dismissing it. I noticed he still owes $155. Is that court cost?
It's a PA.
Judge, you have it on.
Okay.
I can't find it. Wait a second. I hear you, the diversion docket, I see it. Commonwealth versus John Anderson.
And I'll enter an order when Miss Mylon tells me the court costs are paid.
$155, and I'll,
So the DPA that he has not paid off.
he needs to pay the $155.
Your Honor, if he's.
He needs
completed
to pay the
everything-
$155. Okay, when he pays the $155, I will sign the order that's submitted.
In the show calls.
Show cause docket. It's on the 11, it's 22. Okay. So we will go off the record. Thank you, everybody. Be seated, please. Okay, let's do the 1 o'clock child support docket. Severe versus severe.
It's paying, we would just ask for review September 19th.
Okay,
So
Shelton versus Shelton.
respondents paying, September 19th, please.
Stites versus Cowgill.
We have the 19th as well, Judge.
Cooper versus Cooper.
Respondent is current, we could have the 19th of September for review.
Hill versus Haywood.
Mr. Haywood is now making his payments, Judge. We could review it the 19th of September.
Center versus Collins.
Judge, this is our motion to update the payment amount to add an arrearage. It is at the request of the respondent. He wanted to cut down on his arrearage, so we're adding $50 a month at his request, and all parties are in agreement with that.
That's unusual, isn't it? Commonwealth versus Raisin.
Mr. Raisin is here. I've spoken with him about this. This is our motion for contempt. He had an out-of-state order that we have now pursuing. He is going to make payment. We're asking that he be held in contempt and that he purge himself of contempt by paying $500 on or before July 24th.
What's the arrearage amount?
Current arrearage is $2,159. I believe he's setting that up to be, we can pay online. Is that correct?
For some reason, it's not allowing me to get online, which I have proof of. It's automatically coming out. We can actually up the amount. It's only at $99 a week right now. We can up that to like 150 to try and catch up on the arrearages, like each week.
What state is this from?
Georgia, sir.
What do you want to do, Mr. Hurd?
Judge, I do think he is trying. He's been in contact with my office, so I'm fine giving him that July date to make some payments on it.
Okay, you have an order?
I do.
So, okay. You can get a copy of the order. It'll be stamped downstairs. Did you put these online? They enter. Is your Taylor Road still your address? I guess it is.
Mr. Raisin, you're still live on Taylor Road, correct?
Yes.
They'll mail you a copy of the order.
Okay, perfect. Thank you.
Yeah. Thrasher versus Thrasher.
Judge, this is our motion for order and judgment, just establishing medical support. I have to respond.
Okay.
That's all I have, Judge. Thanks.
She did.
So.
About 4 minutes till we're supposed to start, but I could call, Anderson versus Walker.
I believe Miss Capps is on that case, and she just stepped out, but, Mr.
We can
Long.
get her back in there, I guess. Did you get Miss Capps back in? No.
Hello, I'm covering for Miss Fisher today on behalf of Apple Red.
Oh,
Judge.
what we have here?
I had filed a motion to modify the party's original agreement, and we've been in discussions. I think we're hashing out an agreement, and we'll probably have a resolution. So I just asked if you could pass this case.
Well, gladly. What issue are you working on there?
We're redoing their agreement to where they're gonna have joint custody. And then one child's gonna be living with my client, one child's gonna be living with Miss Anderson. And we're hashing all the holidays because their other agreement didn't have that spelled out.
Okay, I'll just pass over and y'all get ready to come back out and announce it, okay?
Perfect, thank you. Thank you.
The next case is West Bend Mutual Insurance versus Fletcher. We just received a call. Mr. Wilkerson said he's gotten tied up in some traffic and is gonna be about 15 minutes late. And so we'll pass over that and come back to it. Vetter versus Vetter. Just a motion to submit the matter for entry of a dissolution. Is anybody here on that? Vetter versus Better, Tim Hendricks, Will Cut. No, I'll take the resolution then. John David Dishon versus Ricky Spears.
David Cross for Mr. Spears, Your Honor.
Hello, Mr. Cross. Hello, Mr. Levitt. I haven't seen you for a while. It's a pleasure to see you here.
Good to see you again.
Yeah. Well, you have a motion to set for trial. Is this a timber trespass case?
It is
Have you taken all the discovery involved?
all the discovery I wish to take. It was
Okay.
filed last July.
Mr. Cross, do you have any additional discovery, expert witnesses, or anything that need to be disclosed?
We do, Your Honor. We have complied with Mr. Lavitt's discovery request in writing. There have been no depositions taken. So I really don't think it's appropriate to set the matter for trial yet. If you want to give us a discovery deadline, that's probably a good idea.
Always take the proof live. You don't have to take depositions, you know.
One other thing, Judge, concerning
Yeah, speak up a little bit.
discovery, I'm waiting on responses to requests for production of documents.
Okay, there was a motion to compel that you
Yes.
filed. What does you have to speak up some because the acoustics here and Mr. Cross is over in the comfort of his office in Albany over there.
Yeah.
Could you tell us what you think he owes you as far as discovery?
responses to requests for production of documents.
Well, what documents do you want?
Uh,
You got your file where you would get particular and I can order it.
it's claimed that he has certain documents, but he didn't give them to us, and I don't know.
What documents are they?
Any documents that, he proposes to use, he just didn't answer the.
Well, tell me what kind of documents you want that you think he has.
If he has any documents concerning, location of the timber,
You have any surveys, timber cruises?
Your Honor, I had Miss Fields working on this, and she's departed for Somerset, of course. But it was my understanding we had complied about right before she left, about 10 days ago, with Mr. Lavitt's request. Now, I will review that again and confirm that, but I really think everything we have in hand, we've sent to him.
What did
Doesn't
you,
mean we won't come up with something else.
what did you send?
Your Honor, we sent Mr. Bell at one point in time had done some survey work on it.
I don't want to
Yeah.
know how to make a clock. I just want to know what time it is here. What did you send?
Okay, I don't have that in front of me to give you a
What did
specific.
you receive?
nothing.
He says he's received nothing.
Okay, well, Ted, you didn't get anything in the last 2 weeks?
You don't know what you sent. He says he's received nothing, so we must presume that he's received nothing. So
Yeah.
I'll give you 10 days to send in any plat, any deed, any boundary agreements, anything that you plan whether they're for or against your side, send it to him within 10 days. Okay, what else you need, Mr. Lavitt?
The other thing I requested, Judge, is an order, scheduling order for anything else to take place prior to trial.
Well,
I
I
can,
have my normal order that I do, and that people have to say that they've completed discovery. They're ready to go. Now, if you're not gonna do discovery, which evidently you say you don't desire to do anymore, are you gonna call a land surveyor or a boundary line, somebody to do a cruise of the timber or what?
both. I've got a forester and a surveyor, Judge.
Okay, you have a forester. Have you disclosed that to Mr. Cross?
He hadn't asked for it.
Well, I didn't ask, okay, let me ask that
The
again.
answer
Has
is no.
Mr. Cross asked you for anything?
No.
Okay, now we got that. Now, have you provided it to me?
If he asked me, Judge, you know.
I'm telling you, he doesn't have to ask you. I'm telling you, provide him with what you've got and you make reciprocal discovery on this thing.
I will.
And Mr. Cross, do you have a timber cruiser?
Your Honor, at this point in time, we do not. We've consulted with one, but we don't have a report. But of course, well in advance of trial, Mr. Lavitt would be entitled to whatever we have as soon as we firm that up.
What he's saying is this was filed last July and it's time to proceed with it. And you don't even have an expert yet. So within 30 days, you need to acquire before the next rule day, which is July the 25th. You'll need to, if you're going to use a timber cruiser, you'll need to be under contract with him, and he's going to provide you with his cruiser, and I guess you can go out and get your cruiser. And then are you going to have a surveyor? Did you say Mr. Bell was your surveyor?
Well, Your Honor, probably not, because this is an unusual case. It's not a true survey case. It's more of an estoppel case. But Mr. Bell is the expert witness. I will say that. And Mr. Lavitt knows that.
You don't think it's a regular boundary?
Well, Your Honor, it's a strange set of facts for a timber case. I'll say that.
I wouldn't expect any less than that.
Oh, I wouldn't think of bringing anything else before you unless it was of the most unusual nature.
If there's anything reasonable, it would have been settled, wouldn't it?
Yeah.
Correct. Of course, I didn't file this suit.
This is
but-
a boundary line dispute. Someone has encroached. Tell me what it's about then.
It's conversion and trespass, that's all.
Well, there
No,
has to be
Your
a
Honor,
line.
it's
Wait,
far from what Mr. Lavitt said, Your Honor.
Mr. Cross, wait, let him, you'll get
Okay, sorry.
Okay, what do you say? There is a boundary line between these two properties?
There is.
Someone crossed the boundary line and took some timber on your client's property.
A joiner did, Judge, an adjoining landowner did.
Well, I mean, somebody.
Yeah,
did.
that's right.
Okay, and so there's a dispute. Now, over what period of time did this take place?
This took place March 25th of 22.
Okay, now, Mr. Cross, you say that it's not a budding landowner who's gone across a line. What do you say? What's the estoppel aspect of it?
Here's what happened, Your Honor. Here's what we allege is that the plaintiff and defendant were going to have the property surveyed to determine the line. The plaintiff went ahead and marked the line so the defendant could cut timber. That was agreed upon and recognized. Subsequently, the property was surveyed. The plaintiff did not like the fact that he'd given up that much timber, and the plaintiff filed suit. So it is a strange set of facts.
Okay. Did your client have a survey done?
Derek Bell.
I'm done. So,
Yes, Your Honor.
so both of them use Derek Bell. Both parties are gonna use Derek Bell, is that right?
I think so, Judge.
I think we recognize that's his
Mr.
work
Lavin,
is good.
do you have any other survey other than Derek Bell?
No.
Okay.
Don't think so.
So do you agree that they marked the line, then had the survey, and the survey wasn't the same as the line they marked? Is that what you're saying? You agree with that?
No.
Okay, well, that's why we'll have a trial.
Yeah.
That's right.
Okay, so you don't need a survey. He'll be testifying as an expert witness, Mr. Derek Bell, and do you have plats, Mr. Lavin?
Yeah. He's gonna serve, he's gonna testify,
Well, I
Judge,
don't,
where the
yeah,
line is.
Okay.
And that,
and then your timber crews will say how much was
he
on
came
each
across
side
the
of
line, cut the timber and carried it off and took our timber and made money on it and didn't give us any of it.
Yeah, okay. Okay, well, let's, y'all have all your discovery exchange. If you got any expert witnesses you haven't designated by the 25th of July, we'll come back here on the 25th of July. If y'all hadn't reached an agreement, we'll set a trial date, okay?
Thank you, Your Honor.
July 25th, Judge?
Yeah, that's the next rule day. He's supposed to have certain information to you, but within 10 days. Okay?
I would.
Okay, you want to draw an order and send it?
I'll fix that up.
Okay, thank you.
Thank you. That's all I have, Judge.
All
Have a
have. Thank you.
Specialized Loan Servicing LLC versus Bobby Garman.
Good afternoon, Your Honor. Chris Wiley for the plaintiff. That is my motion for default judgment and order of sale.
Now, what's the underlying debt here?
The amount,
Yeah, what was it for? What was it? Some mortgage or what?
yes, it's a mortgage foreclosure.
Thought I saw that. Okay. We'll
I'm
go ahead
just-
and, we'll go ahead and sign it. I don't know whether I'm sorry, I didn't see you come up. I was looking at, what do you have to say?
Sure.
I'm
Lisa
your
Garman.
represent, it's Bobby Garman and Lisa W. Garman.
I can't hear you. I'm sorry.
It's Bobby Garman and Lisa W. Garman is what I got served.
Yeah. Tell me what do you have to say?
I just have to say that I've got a son in the process of buying the property and alleviating this debt in total that is owed to SLS. And I just need 30 days.
This lady is appearing here today and says that they will satisfy the debt if you'll give them 30 days.
Your Honor, who is this lady?
Well, can you see her here?
I can see her, yes.
She is Lisa Garman, right?
Right.
She's one of the parties.
Oh, okay. I didn't hear her identify herself.
I identified her. She didn't identify herself.
Oh, my apologies.
And what she says is what's your son's name? Bobby?
He's in the, Logan Wells is in the process and has contacted some of them.
The plaintiffs you're talking about? So her son Logan Wells is in the process of obtaining financing to pay off
Yes.
your now,
Yes.
is this loan, Counsel, do you think this is an upside down loan? Do you think the property will bring enough to pay y'all off, or? Are you familiar?
I have no way of knowing. I haven't seen any kind of a recent appraisal.
Okay. Well, the reason I was asking is it might be to your advantage to give them a few days to see if they can pay you off rather than go through the expense of that. I don't think, would 15 days, can you do it in 15 days?
Well, they were in the process of appraising it and they're waiting.
Who's they?
My son and the loan officer. Where he's
From a bank, what bank is he working with?
Citizens.
Citizens. Well, these people are entitled to a judgment on the thing. I will tell you, I will hold it in abeyance for 15 days.
Okay.
Okay. And Counselor, I will sign your judgment in 15 days. And I don't know whether I'll refer it for a sale yet. I'm going through a transitional period on that, but within you can go ahead and submit or it's probably, did you electronically submit a proposed order?
Yes, it's been electronically filed.
We'll hold off on it on 15 days.
Okay.
And I always feel like if someone can pay you off in full, it does away with any risk that you might have as far as what it might bring. Okay.
I certainly agree. Just I've seen a lot of those fall through. So that's the only problem.
Hope springs eternal, doesn't it?
That's true.
Okay. Well, I'll hold it for 15 days, ma'am. And you see if your son can pay them off in that time period. If not, I'll go ahead and enter the order. Okay.
Okay, thank you.
Okay. No problem.
Thank you.
Yeah. Thrasher versus Thrasher.
This was our motion, Your Honor. Applehead represents Miss Thrasher. We have some indications the parties may have reconciled and this issue may now be
You'll
moved.
pass it over?
Yes, Your Honor.
Okay. Pass it over and I'll pass it generally and you can redocket it if you need to.
Thank you, Your Honor.
West End Mutual Insurance Company versus Fletcher.
Good afternoon, Judge. Mike Van Sickle for the plaintiff West Bend.
Now, Mr. Wilkerson, you filed some documents here and counsel for the other side says that you did not file within a time period of the deadline given by the court. Is that what you're saying, counsel?
Yes, Judge, we had filed a motion for judgment on the pleadings and prior counsel for the defendants had withdrawn. I made a motion to withdraw. The court ordered that and gave them 60 days. And then we re-noticed it, Judge, after the 60-day period. The court heard the motion. The Fletchers, the defendants did not appear for that hearing. And nor did they have an attorney appear on their behalf for that hearing. So the court granted our motion. And Judge, this is just our motion I don't think the order was actually ever signed. So this is just our motion to ask the court to sign the order granting judgment on the pleadings to West Bend.
Mr. Wilkerson, you have filed an answer now. Is that there was already an answer filed in the pleading and this was a motion. Have you supplemented that answer or do you see any valid defense in this case?
We are, Judge.
What is the valid defense that you see?
Well, at this current point in time, we reassert all the defenses that have been set forth in the answer.
Well, that's kind of boilerplate here. I'm
That's
asking
correct.
you to get cut right to it and tell me what valid defense, because I'm going to sign this judgment because of the dilatory way they've handled this thing, unless you tell me there's a legitimate defense here.
Judge,
Tell me what it
immediately
is.
when we entered the case, when my office entered an appearance in the matter, we propounded some discovery on the plaintiff. And we've been waiting on those discoveries to be answered. As a matter of fact, we asked for that. Previous counsel prior to my involvement does not appear to have engaged in the discovery process at all.
What do you believe the legitimate defense is to this?
There, a court in satisfaction, Judge, there very well could be that there's been partial payment. There's a litany of things that we need to see as far as the documents.
Well, I know that you want discovery and you want me not to sign this judgment. I'm giving you an opportunity to tell me if there's any legitimate defense that you are aware of at this time. If you're not aware of any legitimate defense.
We are, Judge.
What is the legitimate defense?
Well, according to the complaint that sets forth that this is just basically as an action sounding in subrogation, but obviously indemnity. We believe that the underlying debt that is owing to the third party was not valid. And so we are contesting the actual amount of controversy underneath the actual the upfront payment that is being sought to be indemnified through my clients. And so we're contesting that amount right out of the gates. And so we believe that there's not been any discovery process, there's not been peering, there's been no exchange of documents or anything in this case. Prior counsel, Mr. Judd, had jumped out of the case. Court was gave my clients some opportunity to get a new counsel. We proceeded and I've entered an appearance and propounded discovery request the day of.
Have you received any discovery?
Judge, that is correct. We have received discovery, and I have actually I emailed counsel to ask for 30 additional days. In fact, we had already propounded discovery upon the defendants back in September 2022. I don't know if Mr. Wilkerson's aware of that, but I've also resent him that discovery, and we have been engaging in that. Judge, I would say that our motion for judgment on the pleadings was only with respect to the defendant's counterclaims against West Bend. But it was not with respect to our claims against the defendants, which would still remain pending. We only filed the motion for judgment on the pleadings with respect to their counterclaims against us.
Well, let me tell you what, I'm going to give them an opportunity to receive your discovery, and I want you to redocket this for July the 25th. And on that date, I will be inclined to give a judgment on the pleadings involving the counterclaim. Okay, I want the new counsel just to get an opportunity to look, see if he feels like there's any valid counterclaim. And then what kind of discovery will you need to take on the underlying claim to defend the claim?
We requested some production of documents, Judge, and that the case file, the underlying claim, those documents are just essential for us to be able to.
Okay, well, let's see if we can get those provided. Then,
Judge, if I may, I think the court had already granted the judgment on the pleadings, though Your Honor just hadn't signed the order yet with respect to the counterclaims anyway, and we're perfectly happy to.
Let me tell you, anything is not in place that the court hadn't signed, okay? And when I'm telling you that I'm 99% sure that I'm going to sign this, but I'm not so sure that these folks have had anybody really take a look at this for them yet, okay? And so I'm inclined to go ahead and sign that ultimately, but out of an abundance of caution, I'm going to give them time, this new attorney, to take a look. And I know Mr. Wilkerson, he doesn't practice in my court frequently, but he's diligent and he won't be tarrying around. So I want him to take a look. And then when we come back here on the 27th, in all probability, I'm going to sign the order, which I initially indicated that I was going to enter, but did not sign. But by then he'll have an opportunity to take a look to see how much discovery, and we'll advance your other claim here, so you won't have to wait. I think that if I do this all together, we could very possibly take care of any appellate issues that we might have. Okay.
Thank you, Judge.
That's what I'm going to do. Okay, and you get the discovery to him, and by the time we come back over here, you come on the 25th and tell me why your counterclaim should not be ruled against on the pleadings and how we should proceed on the underlying claim. Okay?
Certainly, Your Honor.
Okay, thank you very much. Now, do we have a settlement in Anderson versus Walker? Anything to announce?
We do, Judge. I've got an agreed order to
You come
submit
up
to the
here
court.
and announce. Are they still present?
No, they've all left.
Well, I always like them for to come and have it read in front of them, so there's no, come on up here. Yeah. Okay, well, just keep it over there and recite it. Okay. Has she left the building all right already? I guess so. What's the agreement?
And she did have counsel, Judge, that reviewed this with her. The last time she was in court, I think she.
Okay, well, let me tell you what the agreement is.
The parties are gonna have joint custody of both of their minor children. My clients is gonna have the daughter reside with him. Miss Anderson is gonna have their son reside with her. They will each do visitation on a come and go basis, given the age of the children. No child support will be sought by either party. We have an equal division of any school breaks, also equal division of holidays. And the parties are going to split any uncovered medical expenses, share in joint decision-making for education, and then they will each respectively claim any tax deductions or credits for the child that is residing with them.
Okay. And both of them sign it?
That's correct.
You submit it, I'll enter it, okay?
Do you need me to e-file it or can I just send? You can send it. Okay.
Okay, thank you very much. Connor versus Honeycutt.
Chair.
Are these the orders that were attached to your pleadings?
Yes, those are the ones, and on the way down today, I learned that they were terrible copies. And so I was able to make the best copies I could.
Yeah,
And
I could make them out.
yeah, well, and that I found out, I talked to Ms. Capps about that. And
Okay, so this is your client, Mr. Honeycutt.
He is, yes, sir. This is Doug.
And this is your client, the Connors. And I've read the pleadings, and this is an attempt by the Connors to establish de facto status.
That is correct, Judge.
Okay. And I read your pleadings, and if you want to make your response to it right now, you can.
Well, the pleading that I have prepared is basically this court doesn't have jurisdiction in
Yeah,
this case.
that's the reason I want you to make your pleadings before we talking about factual things, because the first thing is.
Yes, we have this original case. It's going on right now in Pulaski County. All we've got is Clint Harris's order that he has signed. That's the last order that's in existence.
Was he a special judge?
He was special judge on that. There was some kind of a problem, I think, with Judge Venters. Joey Venters became counsel or something, and of course she had to recuse because that's her stepson. I believe that was the etiology.
Miss Capps, you established a file with this case here, and it was attempted to be heard in Clinton County, but I didn't feel like your client had received proper service on the thing, so I put it off to today to make sure that he had an opportunity to be served.
Right.
And be present. Is that correct?
That's correct, Judge.
Okay, now, there is a case going on as far as custody of this child up in Pulaski County.
That's correct.
Now, but your clients are not a party to that.
Judge, at the
Are
time,
your clients a party to that?
they were listed as a
Are
party,
they-
but they did not sign any orders.
Well,
There's
I'm
no
just
interest.
asking, I'm not asking you to argue the case. I'm just trying to get everything straightened out in my mind there. They're a party to that action up there. Is that correct?
I don't know if they were actually served in that case, and they did not have a counsel. They were just named because they had been previous foster.
I'm not asking for an argument on it. Are the Connors a party to that case up there? I don't believe they are. It didn't.
I don't know that I don't think they're parties to that.
No,
But okay, so that one up there is Doug versus mother of the child, Brittany Jo Vaught.
yeah.
And that was.
And they had no standing in it.
That
And they didn't enter in it up there to try to establish de facto. So they're not in that. And if they were in that up there, I would immediately grant your motion to say that was a proper venue up there. But in your allegation is the child, and I read your pleadings, was the child was left here for a certain period of time.
Yes, Judge.
With an agreement while the father received some sort of treatment, which was unclear to me what he was receiving in the pleadings.
We didn't have any kind of, that's what they've alleged in their pleadings.
I knew I read it in somebody's
Yes.
pleadings, yeah.
That basically, as we've put in our pleadings, our clients tried to assist Mr. Honeycutt
Well, I'm trying to see how your clients are in front of this court.
Okay.
Okay.
We're in front of this court because this child has been residing in Cumberland County for well over a year. So I thought that was the appropriate venue and jurisdiction to file this action because this is a different action than what's filed in
And
Pulaski
that, it
County.
is a different action. And it could have an independent cause, you know, but now these de facto things are a little tricky for me sometimes. You know, you have to find out whether the child is present was of under a court order or that sort of thing, which makes the time not run if that's the case. There are all sorts of hoops that you got to jump through because I've been wrong on virtually every one of those hoops at one time or another during the time I've been here.
But I know one that you were perfectly right on. Thank you very much.
Yeah.
At least one.
Yeah, I might have been right on one, but you remember the ones you're wrong on. You
Yes,
know?
sir.
And Judge, it's my
But-
understanding that de facto can be established, one, through the statute by the criteria of the time period that's required. And specifically in KRS 403-271A, the last sentence of that provision says any period of time after a legal proceeding has been commenced by a parent seeking to have custody returned. So
And there hasn't been.
there has not been any time because Mr. Honeycutt had temporary custody through that action and he wasn't seeking for return. So I don't think they told the time frame based on that wording of the statute. It's clear and concise. Then
Let me-
even.
Let me stop you there.
We
What's
told
going
it on that in our response.
What's going on in the case up there? Has it been finalized?
Well, nothing's been going on.
Could you get behind the microphone? I can hear you. better.
I'm sorry, Judge.
It's okay.
Yeah, this is going to be recorded. In my understanding, this case had lay stagnant for a period of time.
That was between him and the biological
Between
mother.
him and, yes. Now, well, you know something, I actually see, the Connors listed as respondents in this case. I hadn't noticed that at first, but, I've given you a better copy up here. Brittany Voss, and Eric and Leslie Connor are listed in the action that he brought up there as parties.
Judge, if I could get the.
Well, if counsel will let me finish, I've got two or three things I need to go to.
Go ahead.
Now, here's another thing that we're gonna have to cross. We don't need to file a separate action. In our response, we've specifically told the time by saying that they're not de facto custodians, and we demand the return of the child. So I think we've told it. That if we haven't, it's just a matter of a few days that we'll be able to do it. I think we've told it. Here's the other thing, though. It's very specific to the law. And this will be, of course, this will be facts that you're going to be determining if it stays here. And I don't think it stays here under the facts. Specifically, these very kind and wonderful people, and I'm not going to say a terrible single bad thing about these folks. We all agree that they are wonderful folks who love this child. Having said that, procedurally and legally speaking, the fact that they took dad in along with the child and kept him there for months defeats their claim under the law for any claim of de facto custodianship. But of course, it's going to end up being a matter of fact finding under KRS 403-270 sub 1 for the court to be able to make. And it's a cookbook, a checklist that the court has got to go through and make. And Judge, I think the facts as I know them right now, I've had to get this one ready quickly because he finds out that there had been court going on and he had not even yet been served yet.
Well, there wasn't any court going on.
Well, I understand that. That's what let me just make that clear. He understood that there was a case before the court, and I assured him no, if you weren't there, this court, nor any other court would have entered something. But it got passed over. We got some notice, directly from, Ms. Capps, and then we got our response and I think the appropriate motion, to dismiss filed. Venue is appropriate in Pulaski County, and yes, and quickly looking at it, I did not notice. They are parties, although they've
I
never
just
entered.
I can see it now that it wasn't as clear as why were they parties?
I don't know. This was brought by Jennifer Thomas.
Well, let me ask, why
If
they
I-
were parties up there?
Can I give you a brief history of the case, Judge, just so you
Tell me,
understand?
Tell me.
And that
why they-
answers why they're
Well,
parties.
Becky, I want to know, they had the child with them? Was the
They
reason?
were, at the time, they had been foster parents until Mr. Honeycutt's DNA was done because the child had been removed from the mother. Mr. Honeycutt was not even involved or known to be anything associated with this child until after September of 2022, when a DNA test was done. Then once that was done, then he was allowed to contact the cabinet, and then they proceeded in filing this private petition. The only reason why these individuals were named were just because they were the foster parents that the child was residing with at the time. Once that order was entered, this action was done. They're no longer foster parents. That time goes away. It can't be stopped because there's a court proceeding involving them, because they're not actual parties to the action seeking custody.
And it's in the statute, appropriately, any person who has physical custody of the child or.
I didn't know they had physical custody. Somebody,
Physical, now, I used inartfully,
that's the
physical
reason-
possession,
That's the reason they're parties, because they had physical custody.
physical possession, I think.
What do they call it when these fathers lists that they put people on? What is it?
Putative father.
Punitive. Was he on the punitive fathers list? or-
No, he wasn't.
Well, and that's, the testimony is gonna show that the cabinet had his information from, Brittany, had his information for more than 14 months before we believe this to be a fact, before they even let this know. So he would have known it many months before. Once he found this was his child, he stepped up to the plate and took his responsibility seriously and appropriately, and went to Jennifer, got this thing started, which was admirable and correct. Now, there's been hearings in Pulaski County where all of them have been in the courtroom at that time. The plaintiffs here, the petitioners here rather, have been in the courtroom, and there's been interplay that we've put into our motion where.
I saw that, but the fact that they're in the courtroom because they have an interest in what the child and everything should not be held against them. I mean, they still.
Not at all.
You
But
know,
what the reason I included this was, one, to show they have notice and knowledge of it, and two, to show that it's quite possible that they don't want it decided in Pulaski County, and thus brought it down here in order to be able to do it. I think the evidence is quite clear that they want these cases separate and apart. And just the reality is they are not. It's one child, all of these people together, and it needs to be decided by one judge. Now, Judge Harris has already heard a lot of testimony on the thing, and theoretically, he is more familiar with it than any of us. I don't believe Ms. Capps was a part of that court action. I certainly was not, but I've spent past few days getting
the
custody.
judgment that he had up there gave temporary custody.
Temporary sole custody today.
Yeah.
Just between
Wait a second. Did he give any visitation to the mom? Is mom involved? Is she given up and gone away, or what's the story,
Judge,
Can
she
I-
was
I'll
allowed.
give you an opportunity. Go ahead.
I don't know the answer to that, but if he can answer, has she exercised any visitation?
Yes.
Yes.
Christmas was the last time I've seen it.
I think Judge Harris put some visitation
Let me
on
ask
the
you
end.
something. Let me ask you something. Rather than going through long litigation, however I decided, is there any possibility by agreement that these individuals could be designated de facto custodians, and there could be an agreement on the custody of this child, a joint custody situation.
There is always the possibility of agreements on these things.
Well, let me ask you something, because Judge Harris is a special judge, he would probably have to be reappointed to this case to hear anything. I mean, I'm sure if there's been, or he'd have to come down. Why don't we get the parties in a room to see if there can be an agreement of de facto custodial situation and some kind of agreement on joint custody for the child. It appears to me from what I've seen here that the child's been going from here to there. The mother's given up. Everybody, y'all agree the mother doesn't need to have anything to do with the
No.
child. You agree that?
No.
Okay, and y'all agree with that. Well, we've got some point of, you agree with that, right? Have some point of agreement. Now, I don't know what will happen, but I think they probably do have an independent action to establish de facto custodial situation. And at that point, the two judges would have to probably talk and to see what was the proper venue to pull them into the action there with that new status. Because that status could have been established here separate from what happened in the other case if they check all the boxes. I don't know whether they check all the boxes or not. Okay. So
And-
we're just out without arguing that case and making that potential being there. Could y'all go back to one of the rooms here to see if there's any possibility of doing that?
Judge, at this point, I cannot, in good conscience, in good faith, and with my knowledge of what the de facto custodian statute consists of, there's no way that I can agree or advise him that they should be called de facto. I do not believe that this court, once you hear all of the testimony and look at the exceptions, can, under the law, find that they're de facto
That
custodians.
could very well be true.
I mean, I fully believe that.
And he's heard you say that that you don't believe there's any possibility
Yeah.
of doing that.
Yeah.
But that doesn't mean that he might not want to do that anyway after he sits down, because by agreement, he could acknowledge him as de facto. If he wants to, and with your advice on the record that you don't believe they meet your criteria. I'm just asking if there's any possibility to talk about it. Now, if there's not any possibility to talk about it, then I can schedule this for a hearing.
Well, so.
It's okay.
So here's where we might be able to find some way to be able to come together.
Yeah.
There's always a way to be able to come together and get the result that needs to be gotten, but not necessarily go through the route that was originally anticipated to do that. These folks love this child. They have cared for the child. I mean, that is not an issue in any place, nor does anybody dispute his 14th Amendment, if nothing else, right to due process with respect to his child. And it's all there. I believe that if the parties through counsel, with counsel, and with advice appropriate, were to put together an agreement that gives everybody a piece of what they want, I think that we can do that. I've worked many times with Ms. Capps, and we haven't had one yet that we haven't settled. Now, the problem that I have is this: I am gone for the entire month of July. So it would, in order to be able to get together for a hearing, for example, I would have to beg the court for something in August.
Does everybody agree that the child is safe now?
Everybody agrees the child is
that the
safe.
child should, if there is, ultimately the child has to be uprooted, that it should be uprooted once.
Well, here's the problem.
Yeah.
The document under which they're holding the child is, I haven't seen it, but I have been advised that this was when he was in need of hospitalization, something to do with his kidneys, I believe. And they wouldn't take him to the hospital before they went to the lawyer's office.
I don't.
Well, no, I'm not understanding
Never
the
heard of
court.
such as that. Did you? I mean, they're holding somebody hostage to not get a medical treatment, to get them to sign something.
They've
Is
continued
the
to pay
court-
his.
Wait. I can hear testimony about that.
Right.
Let me tell you something. It's incongruent for you to stand there and talk about what wonderful people these are and everything, and then say they denied someone medical care until they signed a document on, I mean, those two things are incongruent.
I don't find them incongruent at all, Judge. And
Well,
thank
I
you
know,
for,
I
thank you
do.
for letting me, thank you for engaging in this
Yeah.
interplay, and I appreciate it.
Yeah.
No, that's what I've been led to understand. I have not seen the order by which, the
Do you have the
permission by which
agreement
they've got it.
that you give him a copy of?
But it sounds like it might be some type of a power of attorney to get.
Judge, it looks like, from looking at it, it looks like somebody printed out a blank form that says power of attorney for temporary
Why don't you make
delegation.
us having a copy of it?
Yeah. No, it's not inconsistent at all.
Well, now, was your client attempting to get custody or possession of the child back, for lack of a better word, from before they filed this thing here? They filed this motion to be de facto custodian. Until then, was he wanting to come and get the child?
Yes, the
Did he make a
testimony will
demand for
establish
the
it.
child?
No, Judge, he did not.
So we got
And I've
two
provided
sides.
copies of text messages.
I've got some text messages.
Between
from-
my clients and Mr. Honeycutt, where they have reached out to him multiple times and he doesn't respond.
Okay.
Months
Well,
before
I
this
don't
was
wanna-
filed.
You know, here's the thing about it. Let me see how we.
Yeah.
You don't need to say anything.
Yes. We do. No, you don't need to say that. You don't know what that is. Statutorily, there is.
Okay. You're gonna be out the month of July. Did you-
I'll be out the full month of July, from July the 1st, and actually I'll be returning on the 28th. I'll be in Somerset 3 days during that time
Okay.
period. So August is what I'm looking at. Thursdays are.
I am not inclined to sign any order to deliver the child back to your client on what I know now. Okay. I'm just not inclined to do that. Might be right, might be wrong.
So if we were to call it, rather than timeshare, call it temporary visitation, so dad and his family at least gets an opportunity to spend some time.
I'm all for that.
All right, so.
I'm all for, this, you know, this child's grandparents.
Yes.
Deserve a right to have involvement in the child's life. They are biologically and forever linked to this child. They deserve some visitation.
Absolutely.
But until I unsort this,
Yeah.
I don't know what sort of medical treatment, addictive behavior, whatever has been going on here through all of this, why he wasn't involved. I don't know that, okay? Was that what he was hospitalized for? Is something
on
wrong
that-
with his
on this
kidneys because of drug use? I
Now,
mean,
this particular one, I don't have full details. I've asked for medical records, and Judge, I just haven't had time.
well,
since I've been-
yeah, and I understand, but I don't know, like, my thoughts, where's he been?
Yeah.
Where's he been? The child's been here with them. Where's he been until they start to establish some permanency for the child? And that's the reason I think they might have some kind of claim to establish de facto here. And at some time, these cases have all got to be merged, because the mama is going to pop up one of these days, you know, and if she hasn't been, right now, her parental rights haven't been terminated. So y'all go back and see if you can reach some kind of agreement until we can take proof on this sort of thing. And both of you have an opportunity, quite frankly, you haven't really been given enough time to make a complete defense
I
on
haven't had
all,
my
all
20
the loops
days.
that you got to jump through, okay?
Right.
And you probably hadn't had opportunity to make sure that all the proof that you want me to ultimately
No, I have
hear
not, Judge.
is there. So let's, you know, my grandmother used to say that you measure cloth twice and you cut it once.
Cut it
right?
once.
Okay, so let's go back there and measure some cloth and see what kind of visitation that we can get, okay?
Judge.
And
I was headed for trial the other day. This is another one that you can have. My 7-year-old, I said, you have advice? He said, well, do good for good people, but understand that everybody has a story. And that was my 7-year-old that came up with that. So, let's,
I used to go up to the Kentucky Center of Performing Arts, and they had these story times down there. And they, after everyone told their story, they'd say, "Everybody's got a story. What's yours?" And the person would get up and tell it. Okay, I'll wait here while y'all go back through the thing, see if you can make any agreement. Okay, does anybody else have anything on the docket? Okay, is it 2 o'clock here?
Yeah.
DBO docket. Christy Nicole Lee versus Jared Wayne Stewart.
Judge, I'm not on that case. He called the better case earlier. I came in a few minutes late.
What case?
The better case,
Yeah, let me go back. Vetter versus Vetter.
Yes.
It was just for entry of a judgment, wasn't it?
Yes, sir. We.
Get behind the podium.
Yes, sir. That was my motion. We went to mediation last year, got everything worked out, party signed it off. I sent over agreed judgment, agreed motions to waive. It's never signed. Followed up several times. Mr. Wilcutt filed a motion to withdraw, but.
Wait just a second.
So we just.
Pull those doors back there. Mr. Got a voluntary assistant bailiff back there, so. Just do me a once upon a time thing here real quick. I read it. I couldn't tell much about it.
Yes, sir. We went, it's a divorce. There's a couple of minor kids, but they're older teenagers. Went to mediation last October. Got everything worked out. Everyone signed off on global.
And then somebody withdrew.
I'm sorry?
An attorney withdrew?
After the mediation, we sent over an agreed waiver, agreed motion to submit an agreed decree incorporating it was never signed. We kept following up. When I filed the motion to submit, Mr. Wilcutt moved to withdraw. I don't believe it's been entered, but maybe it has been since I last looked. So we just want to send over a decree with that mediation agreement attached.
You think his client was Melinda, is that right?
Yes, sir.
You just think she refused to sign it or what?
Mr. Wilcutt's email's response to our follow-ups was he's waiting on his client. So.
It would appear that she refused to sign it. And so you don't have an agreement until it's signed, do you?
We have an agreement out of mediation. That has been signed. What I sent over to Mr. Wilcutt was an agreed
Do
decree.
you have a copy of the agreement and mediation? Those usually aren't entered.
I don't know if I brought one with me today or not, but I have one. Yes, sir. I can.
Well, if you send me one of those, I'll let you supplement the record and notify him. Have I let him out of the case yet?
I don't believe so. I've not
Okay,
seen.
well,
you.
notify him that I've requested the mediation. And if he doesn't immediately file something within the next 10 days, give him 15 days that I'm going to enter the judgment. Does that sound fair enough?
15 days for him to respond or
Yeah.
file.
There's just an agreement on mediation here.
Do what?
There's an agreement on mediation here.
Okay. Okay, well, I have the agreement on the mediation in front of me and tell him that if he doesn't respond within 15 days. But she hasn't signed. Maybe she has. Come here and look at that. She electronically signed this. Right here.
I think we mediated with Mr. Keenan, and that's common for him to send around.
her email is mywetduck1110@gmail.com. So I have a copy of what she has signed and just tell him that if he has 15 days to respond, and if not, if I don't hear from him, then we'll enter the judgment, okay?
Yes, sir, I'll do
Okay,
that.
thank you very much.
Thank you. Have a good afternoon.
Okay, is there anything else come before the court? What time is the jury coming? 2? Yeah, I need to clear the courtroom for a confidential matter is. The jury coming at 2:30. Okay, the folks in the confidential matter here. Thomas here. Okay, it's 24 AD 0001.
Yes, Your Honor.
Says a motion for hearing on termination of parental rights to finalize adoption. What do you have?
We have, we have the adoption. We would like to have it approved.
I can't hear you.
My apologies, Your Honor. The adoption is ready to be heard and the termination of the parental rights for Eleanor Rose Fairley. This is the adoption hearing.
Well, have we already terminated parental rights?
The father, the biological father has agreed to give up his rights. The filings are in the file. He has filed his written notice. He filed the AOC.
So he's agreed to termination. Do
Yes.
you agree with that?
I do, Your Honor.
Yeah. Is there any reason why we should not go forward to finalize the adoption?
Not that I'm aware of, Your Honor.
You're a guardian ad litem in this?
I am.
Okay. So
May we
you want to take
proceed?
some testimony?
Yes, sir.
Okay.
The first person would be the mother.
Raise your right hand, please.